All right. I'm pleased
Folks,
to
one
introduce
voice at
this
a time.
panel to talk about the future of affirmative action and DEI 2.0. So our panelists all the way at the end there are Adam Klein. He's managing partner of Outten and Golden and founded the firm's class action practice area. In the middle, we have Erica Ozer, NYU grad. She's executive director, senior associate general counsel at Boston Consulting Group. And our commentator today is Michael Delikat of Orer Carrington. He's a partner in the New York office, was the previous chair of Orer's global employment law practice for over 20 years, and he is the founder of the firm's Whistleblower Task Force. Please give your attention to this esteemed panel.
Thank you. And not to derogate NYU, but you have three panelists here who are all graduates of the Cornell School of Industrial and Labor Relations. So let's have a round of applause for that. So what a difference a year make. If you want to think back to, what month are we in now? June of 2024. The Biden administration was all in on DEI, and we were talking about backlash to DEI coming from a number of different quarters, whether it was activist shareholders, state attorney generals, litigants, individual litigants who wanted to take on DEI on a reverse discrimination theory. And a year later, we've obviously had a change in administrations. I think everybody here is aware of that. And it's changed rather dramatically. I don't know what to say other than 180 degrees different. I don't know if you can make things any different, but it's gotten to the point, and this is not, I'm not overstating it, that this administration is demanding where it has leverage, either by virtue of an executive order, a government contract, or some other government approval that's required, that companies eliminate the use of the word diversity in describing any of their employment-related programs. So I don't know if you could get more polar than those two options. Very, very quickly, how did we get to this point? I think, the seminal event certainly was the Supreme Court's decision in SFFA. Yes, that was a case about college admissions, but Justice Gorsuch told us that that case involved Title VI of the Civil Rights Act of 1964 for colleges and universities. And Title VII comes from the same overall statute. And he said both statutes codify a categorical rule of individual equality without regard to race. Well, once that came out of the SFFA case, backlash really got into first gear. Conservative groups got involved with litigation. State attorney generals from both the red states and the blue states jumped into the fray. From the red states, those attorney generals were filing lawsuits, sending threatening pronouncements to companies who they felt had gone too far in their diversity efforts. And the attorney generals from the blue states were doing something different, warning companies if they walked away from their DEI programs totally, they could be subject to individual suits, shareholder suits for not living up to their promises with respect to diversity. And then we get, of course, to the presidential election campaign, where the attack on DEI and wokeness was really one of the center planks of the Republican Party in that election. And many pundits now say one of the reasons, especially with the attack on the trans community near the end of the campaign cycle, that made a difference in terms of the outcome of the election. And Trump's promise to eliminate DEI and fire all of the woke individuals, whether they were in federal government or they were the generals in the Defense Department, that was going to be a major push. And if we can say one thing, it came with rapidity that we haven't seen, certainly in other situations. The afternoon following the inauguration, Trump signed the first executive order, and then a series of executive orders on January 20th and January 21st. Executive Order 14151 terminating for federal employees, DEIA programs, Executive Order 14168, terminating gender identity policies. Most important, certainly for those of us in private practice, was Executive Order 14173, kind of the most important anti-DEI executive order, referred to by many as the J21 for January 21. And that one revoked Executive Order 11246, which had been in place for many, many years, dismantled the OFCCP, required all federal contractors to certify under penalties of False Claims Act potential liability that they were not engaged in undefined, unlawful DEI, and they ordered all government agencies to create lists of companies and other organizations like colleges and universities and foundations with substantial assets who were, quote, egregious DEI practitioners, and open investigations against them. There was a date that those lists were due. Supposedly, all those lists went to Stephen Miller. He's trying to figure out what to do with them at this point. And then most recently, and you've heard a lot about it today, but we have Adam here, who's one of the premier practitioners whose career largely was built on the use of disparate impact theory, right? Is that an overstatement? Maybe it's right.
Among other things.
He's got a lot of things going for him, but that was certainly important. But Executive Order 14281 ordered at least federal agencies to limit or eliminate enforcement of disparate impact claims, but private disparate impact claims are still alive, as you'll hear from Adam. This whole setting has had, a dramatic impact on how companies have certainly reacted to this dramatic shift. And I'm going to just run through very quickly, and then we're going to turn to our panelists, some data that we put together. All of this was just published today in the Harvard Law School Forum on Corporate Governance. If you go to their website, you can get the entire article that has a lot of narrative and information about the statistics. But what we did was put together data from the Standard & Poor's 500 companies with respect to changes that have occurred in the first quarter of 2025, and that's all following, this campaign with respect to executive orders, et cetera. And so since January, 59% of the S&P 500 significantly revised or removed DEI-related disclosures in their 10Ks. Only 34% of those companies used the term itself, DEI, in 10Ks filed since January, which was a decrease from 90%. And so that's the first bar chart you see, 2024, 90% of the companies reference the acronym DEI in their public disclosures. That dropped rather precipitously to 34%. Then for those that dropped DEI but still talked about DEI-related disclosures without using the acronym, 78% of the S&P companies still have some DEI-related disclosures. However, 40% significantly revised, shortened those particular disclosures. And so you go down at 19%. Entirely removed diversity-related disclosures, not just talking about DEI, and the trend is accelerating as we sit here today. And I'm not going to go through all of the slides on it now, but some very interesting things. But this one is, I think, also interesting, and many of you, I'm sure, are acutely aware of programs being rebranded or renamed at the institutions or organizations you work for. And so it's obvious that companies, are replacing DEI with other language, the most common of which is the word inclusion, where companies have a defined program for what was previously DEI. 76% now use inclusion as part of the program name, inclusion and belonging, inclusion and opportunity, culture and inclusion. And so that has become the most popular. You see the 76% in the chart there. And that companies are taking very different approaches to what words they use, but they all hover around a combination of trying to capture this particular theme. And so we see a dramatic change in how that's working out. So with that as a little bit of background, I'm going to go to Erica first, and we're happy to take questions as we go through it. And ask Erica, what are some of the most common set of actions that private employers have been taking in response to this blitz of executive orders?
Yeah, thanks, Mike. And I am going to speak on behalf of a sort of network of employment lawyers that I talk to on a regular basis. And I was just joking with Terry Wood, and I said this one of those networks that she actually helped start way back when has now become a full-on therapy group, support group for employment lawyers. But all kidding aside, there has been a flurry of activity that has happened over the last few months in light of the executive orders. And Mike, you hit the nail on the head. There's, what you're showing with those stats is really what's going on inside. So what I mean is, I think everybody cut back their corporate responsibility report in some way or changed the way that they were talking about it, where years ago it was, let's add more, let's have a whole section on diversity. Now let's fold it into another section. I think really what every company is struggling with is how do you find that common balance of making sure that you're in compliance, but sticking to your company's values, making sure that you are thinking about employee engagement, which this is a very important topic for employees, your clients, and your shareholders. And how do you do all of that at once? And I think what you have seen many companies do is try to find a way to keep their values and their commitments without being in the spotlight. And so that's why you see cutting back on some of the language or what's being included in the public reports. You might see less people participating in some of these, I want to call them awards that you can get for different diversity activities. You did see a lot of companies come out and try to reaffirm their values. And that the media might have taken as they're scaling back or they're going too far, and there are, that's something that you saw a lot of media activity around. A lot of talk about meritocracy, making sure that, companies are reaffirming that they choose their talent on who is the best qualified. You also saw some opening up in participation. So making sure that it's very clear that the many different affinity groups that are within organizations are open to all. Avoiding identity-based programming, even if it's, mentoring or sponsorship for women or all the different programs that were maybe parts of those affinity groups in the past, there have been changes to a lot of that. Avoiding the public statements. You've seen a lot of companies say they're not going to have targets anymore. They're not going to have aspirations anymore. And cleaning up wording on websites. There have been media articles specifically about how many changes companies have made on their websites. The name changes, also really important. I think a lot of companies have changed the name, whether it's to belonging, inclusion, or something that makes it their own, related to something within the company that means something to that company and that company's brand. Supplier diversity, backing out on some of the commitments that had been made previously, even with law firms. Many in-house counsel had requests for external law firms, what they wanted to see when it came to diversity, and those stricken from contracts. Less sharing of data, both externally and internally. And I think Mike's data really supports that. So those are just some of the few examples of things that the employment teams have been doing, and a lot of auditing.
Yeah, one of the challenging ones that you've mentioned, and we've gotten a lot of questions on it, are these awards. I think especially interesting to lawyers that different publications have best woman in private equity, best under 40 in M&A, et cetera. And the question we've been getting from clients in the law firm arena is, well, it's one thing if American Lawyer just announces it on their own as a result of their research, but oftentimes to get these awards, firms have to supply a lot of information and data about the individuals that they're pushing for those category-specific awards. What are you hearing about what other companies are doing? Are they pulling back on doing that for fear that, you know, a male who doesn't get that award because there was no basis to put him up for it may be disadvantaged by the fact that the firm has now supported somebody who got the award, and that person will be on a better promotion track or be exposed to more clients on the outside, and so that person, that male in that situation, didn't get the benefit. So any thoughts or wisdom on that one?
I mean, I think to be honest, I think what is going on now might not be what you see later on, but I think everybody just pulled back out of, like, we don't even know what to do, right? Because that's exactly the issue. You're gonna get it from both sides. You can't win. So how do you just stay out of that spotlight? And I think that puts everyone in a tough spot, and you know, people are going around in circles to try to figure out how to do that.
Yeah.
Because it's really difficult.
Yeah, and it's, you know, not just the executive orders of the new pronouncements of the new EEOC, but this administration is using whatever leverage it can. I think a good example of that is 2 weeks ago, I'm sure, or 3 weeks ago, you all read that Verizon was about to enter into a $40 billion merger with Frontier, another communications company, and the FCC was refusing to give them clearance on that merger, not because of any antitrust or FCC kind of issue, but required Verizon to renounce their commitments to DEI. And that required the CEO of Verizon to write a 4-page letter to the FCC, which of course was publicized as another win by the administration, talking about how, you know, they've renounced all of their DEI programs and have moved away from it, et cetera. So this administration has been particularly adept through the executive order program, through litigation, but also through using the power of government approvals or government contracts at getting outcomes. Okay, Eric, another question for you. This is no easy answers, but, you know, global employers that are in multiple jurisdictions and have different requirements in those jurisdictions. In fact, you know, used to be the U.S. led the way on these kinds of issues, now obviously being left far behind and going backwards. But how are multinational companies implementing diversity strategies you know, amidst differing laws, cultural attitudes, and different political sentiments around the world?
Yes, this adds a whole other level of complexity, just by virtue of what you've just explained. And I think you're right. I think in the past, the U.S. would just lead the way, but that's not necessarily true anymore. And I'll give you a really great example of a live, it was all in the news, but Accenture said that they were going to no longer have their global targets in the U.S., and they ended their career development and specific demographic groups. This was all in the paper. And there was a lot of media attention about it in the U.S., saying they're rolling back their DEI. So that's going on in the U.S. Then they're part of an RFP in the U.K. for a large project. And they ended up being disqualified for that because they did not meet the diversity supplier requirements any longer. And it was like, I think it was like $300 million or something, the bid. And this really underscores the exact complexity that multinationals are dealing with. And, you know, employees outside the US are, you know, scratching their head, like, I don't understand. There's, you know, at the same time that we're pulling back on all these corporate responsibility reports, there are laws in Europe that want you to disclose more that are, you know, that are going into effect right now. So you have, even just working on a corporate responsibility report is extremely difficult because you have to meet certain requirements in Europe that you don't want to be disclosing in the US. And how do you do that? And so there definitely is, I would say, a mentality of US and rest of world starting to form at a lot of companies. And, you know, one approach is to, you know, if it's global or if it touches the US and it's the US, you do it one way, and then maybe you relax it a little bit outside the US. And that's something that I think a lot of my colleagues and I have been talking about, and that has been playing out. So if it's something just happening in Germany, for example, it might be common in a recruiting situation where you go out to a college and you have a women's event and you call it the women's event. Well, in the US, that's all gotten changed, and it's the Women's Affinity Group is sponsoring an event and all are welcome. And then in Germany, you keep the name that it's the women's event and make sure it's clear that it's in Germany only.
Right. And, again, this administration takes the view that many of its pronouncements and theories do have extraterritorial application. The State Department, a couple of examples, has sent out requests for certification. A law firm, a global law firm with an office in Southeast Asia that provides advice to the U.S. Embassy in that jurisdiction on employment law in that Southeast Asian jurisdiction, was required or was asked to sign a certification by the State Department in order to keep that work of advising the U.S. Embassy in that foreign jurisdiction with respect to employment law matters. And so, again, that's something that's happening outside the United States. The State Department is telling a law firm that unless they certify that they are not engaged in unlawful DEI or violating any U.S.-based discrimination statutes, they're going to lose their contract to provide advice in this foreign jurisdiction. And we've seen things going to foreign contractors also in foreign jurisdictions. In Spain, the State Department sent out a slew of letters to foreign-based contractors that were providing services to the embassy in Spain. Whether or not those things ever stand up, probably not likely, but we know there have been any of a number of successful legal challenges, certainly on the law firm front, to executive orders, and a lot of people are second guessing what firms did that entered into settlement agreements. But the reality is, the victories now have been short-lived in some situations because they're victories at the district court level. When the things get to the Court of Appeals, as we saw with the first injunction granted against the J21 executive order in the District of Maryland Court, which was a nationwide injunction against all federal government agencies, when the government took that up to the Fourth Circuit, they paused the injunction and have just gotten around today, in fact, to setting oral argument on whether or not there should be an injunction and whether or not J21 is unlawful with respect to the certification or other provisions or violates First Amendment rights. There won't be a decision until well into the fall because oral argument has now been set for September in that case. So again, victories in the courts now are short-lived, and what's going to happen at the Supreme Court, there aren't too many people that are fighting this battle that are confident that much of it's going to stand up at the Supreme Court. Last question, Erica, for you. How are employers handling the regulatory divergence within the U.S. between state and city law requirements? Executive Order 11246 and affirmative action plans on the federal level have been wiped out, as they say, with the stroke of a pen. But many states still have affirmative action plan requirements for state government contractors, especially the blue states, or city law requirements like New York has. So how do you handle a situation like that here in the U.S.?
Yeah, I mean, I think it's really similar to the global issue that we just talked about, which is, I think, employers are just really put in between a rock and a hard place, because you've got to comply with both if you want to do business. It's one thing if you are just if you're just a federal contractor or just a state contractor, fine, that's easier to navigate. But many employers are both. And so to have to comply with both at the same time is quite difficult. But I think it can be done. I think there's a fine dance to be had about how you can actually comply with both, particularly if you're not getting out there and announcing hard targets or doing anything like that. Maybe you have separate RFP responses, right? What you're writing to the state and what you're highlighting for them when you respond to a bid might be very different than what you're going to now submit to the federal government. Maybe you're going to have a slightly different hiring and outreach strategy in one state that maybe you wouldn't have in another that didn't have that state affirmative action program. Maybe you're going to do some different training for those who have to comply with the state or city affirmative action that you would for someone who just, is working on the federal contractor stuff. So those are just some ideas. And then back to my lots and lots of auditing, internal auditing. The employment teams and also hiring outside counsel to help.
Okay, great. Any questions? We're going to move to Adam and dig deeper on disparate impact liability. We know you had a presentation on that this morning, but you're going to hear some of the very
Can
practical.
I ask you one?
What's that?
Can I ask you a question?
Yes, absolutely.
Your partner and I did a piece on affirmative recruiting. Is that unlawful now? On affirmative recruiting, in other words, you're trying to expand the pool of people that you might have underutilized. I didn't see anything in AFA necessarily.
Yeah, well,
that sets
widening
that
the
down.
net, which is the popular term now of
Excuse me?
widening the net of potential applicants
that's
is
no problem.
fine, provided that the ultimate hire decisions are based on merit
Right,
and
that's fine.
not protected
So you think that's
characteristics.
still okay?
So that one's still okay, and it also dovetails a little bit with, interestingly enough, the administration's support of the historically black colleges and universities and that particular executive order, which might suggest that that kind of broadening the net is going to be appropriate, but and anything that shows a preference or is a plus factor, you start working your way back to what the Supreme Court, at least the majority, found was wrong with Harvard and UNC's hiring practices is definitely a dangerous situation.
Thank you.
Okay, so let's move a little bit. Again, one of the more recent executive orders dealing in the employment sphere was the one with respect to disparate impact theory about a month ago. Just let me quote one sentence from that Trump executive order. On a practical level, disparate impact liability has hindered businesses from making hiring and other employment decisions based on merit and skill, their needs, or the needs of their customers, because of the specter that such a process might lead to disparate outcomes and thus disparate impact lawsuits. So, Adam, you have a case now, the EEOC versus Sheets case, where disparate impact is at the center of it. How do you think this executive order and this change is going to impact, to use part of the phrase, the kinds of suits that you've been involved in for many, many years?
Yeah, so thanks for that. Just to tie it back also to DEI, so the equity aspect of DEI is defined as ensuring fair opportunities and resources for all, addressing systemic barriers and biases that may disadvantage certain groups. And I think that's a pretty apt description of disparate impact liability theory under federal, state, and city laws in many jurisdictions. And so the EOC v. Sheets case, by the way, the only class disparate impact case in the federal government EOC docket, that's it. They had one case. The entire federal government had one disparate impact case. And in that case was the result of something like 8 years of investigation before the thing got filed. And it relates to the use of criminal history records for determining employment suitability, which has a racial impact effect.
And what was the reason for that with even Democratic administrations, that they never pursued cases on that theory? Too much involved in doing it, or?
I don't really have a great answer for you. I think part of it is those are much more challenging cases to develop. It requires expert work, statistical analyses. It's not that they've never found cases. That case against Bloomberg, of course, many years ago, Morgan Stanley and others. So it's not that they haven't done them. It's just that it just so happens that even under the Biden administration, the only holdover case that's based on disparate impact liability was Sheets. So, and we now represent the proposed intervener along with the Public Interest Law Center. So that's a case that we're going to take over functionally for the OC. It's a kind of issue and type of claim that I have a lot of familiarity with. I've done a lot of disparate impact class litigation around the use of criminal history records based on its disparate racial impacts. Basically, I don't think anyone would be surprised to learn that there are racial differences in arrest conviction rates, and it's sort of common knowledge. And so, in cases like Sheets, there are other examples. A lot of times what's happening there, and to just answer your question, a lot of times what's happening there is that the employer has a hiring selection procedure or screen that is not job related. let me say that again, not job-related, meaning it has nothing to do with the actual requirements of the job, and yet it's used as a screen for employment. It's pretty common in disrespect liability cases. We had a case, I prosecuted a case against Department of Corrections in Connecticut. It was a physical fitness test. Turns out women run slower than men. And because the government used a cut score, run test, it basically excluded a higher percentage of female applicants to work in a prison. And my joke is, where are they running? So this, again, it was not job relevant. And we actually won that case on summary judgment. So as plaintiffs' lawyers in a class action, won summary judgment. So it's just an example of, I would describe it as irrational behavior or unexamined behavior by employers. And it just goes back to the equity component of DEI. I think a lot of this is just political theater. I mean, just to answer the more general point or react to this panel, I pulled up I guess Google's version of the definition of DEI. And according to our friends at Google, DEI programs aim to create a workplace where everyone feels valued, respected, and included, regardless of the background or identity. They encompass various initiatives designed to foster a more inclusive culture and ensure equitable opportunities for all employees. I don't think there's anything in there that anyone should object to. And in fact, and it's, it's the kind of commentary or philosophy that we try to bring to our cases. And a lot of times we've had experiences, particularly in the settlement context, where there's an entire discussion about how do we promote the interests of the employer through these kinds of initiatives, and to talk about, and particularly equity and inclusion, as a sort of a means to improve the experiences of our clients, but also the bottom line of the employer. Those both objectives can be achieved. And so I just think, just to circle back, Mike, to your question about the Trump EO, it's functionally political theory. It's ahistorical. There's no basis for this idea that merit-based decisions are being impacted or affected. I would argue the opposite, actually, that in fact this impact theory under Title VII requires the use of valid hiring selection procedures or characteristics that relate to the job requirements. And that's actually the correct articulation of a merit-based hiring or employment decision process. There's nothing wrong with that. That's what Title VII requires, many states' laws and city laws as well. And whatever Trump says in his EO, I think he got it wrong, and it's functionally political theater.
Do you think even though the executive order applies only to actions by federal government agencies as plaintiffs in these kinds of cases, that in your private cases, you're going to see the defense now being raised that disparate impact theory is no longer valid, to just try to get that issue back up? And it's been raised before, and Scalia's opinion and all of that. So how do you think it's going to play out on the private litigation side in terms of the impact of this executive order?
Well, I'm not a constitutional scholar, so it's hard to answer the question in the abstract, and I haven't really given that much deep contemplation. I will say I can understand the argument being made. I don't think it's going to get very far. There are plenty of statutes, criminal statutes, civil statutes, that don't have a mens rea or intentionality requirement. I mean, you could list them down your arm. I mean, people are in prison right now for violations of criminal codes where there was no requirement of intent. Think about negligent homicide cases. There's a whole endless list of them. And so if it's good enough to put somebody in prison, I think it's good enough to satisfy a civil rights statute. Also, I also think that it's a little bit of a slippery slope problem for this type of argument, which is that, well, where do you draw the line? You could say, well, disparate impact theory under the Civil Rights Act 91 comes into conflict with, I guess, equal protection under the federal Constitution. But how far down that road do you go? Does that include fair pay statutes? Does it implicate other kinds of statutes that are commonly used in the workplace that relate to employee rights? Wage in our laws, there's no intentionality around unpaid wages. So, for example, just to make the point, if an employee works and isn't paid, it doesn't matter that the employer didn't intend for that to happen. You owe the money anyway, right? So if you just start to unravel the conceptual underpinnings of this equal protection claim or due process claim or whatever the constitutional aspects of the defense argument is, you start to just see how it threads into all kinds of other areas. And, I think of things in terms of what's the boundary condition? Where do you draw the line? Where do you say, well, it applies here, but not there? And I don't know what the conceptual framework would be for that. So it's a little hard to understand it, to be honest about it.
Yeah. And, you settled many major cases over the years that were brought under disparate impact theory. What are some examples of the programmatic relief you were able to obtain in those cases, which now would seem to fly in the face of this administration's position on DEI and also on its most recent executive order on disparate impact theory?
Yeah, so I think the most apt answer to that is our case against the federal government itself. We represented 500,000 Black applicants who applied to be census enumerators for the 2010 decennial hiring or census hiring process. And there, the government was using arrest records to deny applicants employment. We settled the case several years later, created an entire process using APT metrics, some of whom are here, and basically dismantled and rebuilt, reimagined the hiring processes for the federal government for the census enumerator position for the next decennial. And by doing that, we radically reduced the racial impacts of the criminal history records. Interestingly, also largely benefited white applicants. So there's a bit of an irony here. While the framework or notion of the case related to racial impacts for Black applicants in particular, it so happens that when you take away non-job relevant hiring criteria, it generally helps all applicants, regardless of race, in that context. And so that's a helpful notion for employers, because now you're actually taking advantage of a wider array of applicants. You're not wasting, from a societal perspective, wasting human capital. Creating opportunities for people that would have otherwise been denied employment based on reasons that are not job relevant and frankly irrational. There are 77 million people in this country with a criminal record. Denying them employment is a societal suicide. And yet that's, you see that. So that's, I think, perhaps the best example of it.
Yep. Okay, we have like 3 or 4 minutes left, right? And so we'll take.
We have a little more.
Okay, questions from the audience. This is a hot topic. I see nobody wants to
They're
take on any of
speechless.
these issues. Okay, so Erica, any final thoughts that you have in terms of, I was fascinated by your thought, what you're seeing a lot of is, at least for this cycle, people are pulling back, pausing, not necessarily eliminating forever, but pausing certain programs just to see how the challenges play out and how the court process proceeds. And so does that seem to be a majority view of how companies intend to proceed during these uncertain times with the legal aspects not totally worked out yet?
Yeah, I think that's a good summary. I think also there's just so many other factors, not necessarily the legal, but what's going to happen with government contracts? How are we going to be viewed? How are we going to be viewed in the media? There's just so many other factors as well that I think are also playing a role, but I think everybody has just kind of stepped back a little bit to kind of look at everything. But to your, I was thinking about some of the things that you were saying, Adam, and, I think everybody's heart is in the right place here. And at the same time, they don't want to let go of things that, have helped people, have made the environment more inclusive. What you don't want is a divisive employee base. You want people to feel welcome. You want them to be able to perform at their best. You want to make sure you're picking the best talent. So, if you think about that, it's like, how do you get to those things that are really important for employees, for companies, and then not get yourself in hot water and in the news and having to give up on everything?
Yeah, clearly companies are between a rock and a hard place. Again, if they have major federal contracts in the billions, as many do, their responsibility, at least to the shareholders, et cetera, would be do what you have to do, just like Verizon did what they had to do to implement that particular merger. On the other hand, the impact on the employee population and, reputational, as we've seen in many cases, involving Target or, attacks on and changes that some employers made, Walmart, et cetera. That is all still playing out in the sphere of public opinion. And so it's a damned if you do, damned if you don't situation that many companies are facing now. And it's going to be a very interesting, few years going forward as to how all of these efforts that went on for so many years in terms of trying to move the needle in a positive way with respect to DEI efforts. Will that be totally trashed as the administration really attempts to wipe out the word diversity from the dictionary, and certainly the use of it by any employers in describing their policies, but at the same time saying, don't just think you can rebrand your DEI program by calling it inclusion and belonging, because if you don't change anything other than the title, we will be on you, especially for that particular issue also. And a whole new civil fraud unit was set up in the Justice Department to go after a new theory, which, isn't a law anywhere, and that's, civil rights fraud. And so we'll see what's going to happen with respect to that. But I think one thing you can be sure of is this administration will push forward and try to get more wins on this particular issue, just like it did in getting certain law firms to settle with them, even though many are now saying, why did they do that? Hindsight is 20/20. So, Adam, any final thoughts?
Yeah, I was just going to say, just on that, Mike, what's so sort of striking about this entire discussion is that how unserious it all is, in the sense that, Trump's attack on DEI is utterly irrelevant to employers' interests or in conflict with employer interests. I've done these programs, I'm sure all of you have been in. I've not heard anyone ever stand up and sit here and say, I think that illegal DEI should be eliminated. It's just not a thing by anybody. At ABA conferences, at employer gatherings, I've not heard anyone utter those words. Oh, this was a problem. We really needed to get rid of illegal DEI. First off, it's not illegal. And second, it's actually in the employer's interests to do exactly precisely what they say they're doing for any number of reasons, including just profits, just making money. It's sort of like saying companies should stop making money because, that's illegal and we don't like that. It's sort of it's political theater, it's unserious. It doesn't relate to the actual experiences of companies. And here I am, a plaintiff's lawyer. I represent people. And I'm telling you, employers aren't at all of the view that any of this makes sense. So what does it tell you about where we are in life? It's hard to know sometimes.
All
Okay,
right,
we got
have a
one question.
Yeah, hi, I'm John Maitland, management side lawyer for Vermont. The question I had is, are you aware of any employers that are still doing affirmative action plans, specifically the workforce analysis that you would use to back up the broadening your network? Any companies that are still doing that?
We have the state, the state and local, the question was, are you aware of any employers that are still doing affirmative action plans or the analysis that leads up to it? And again, there are, any of a number of states and local municipalities that still have affirmative action plan requirements, and those employers are still going forward with those, even though they're not being used on the federal level. And then in terms of the analysis, I think there are employers, there's nothing that prevents you from doing the analysis to make sure you're not discriminating against the underrepresented populations of the company. It's then taking the analysis and setting up, either goals or quotas that aren't necessarily tied to market availability. So there's been, obviously, that's been curtailed, but for legal requirements,
And also, disability and
Veteran
that's
rights.
still
That's-
on the table. Yeah.
All right, well, thank you.
Interesting times.
Oh,
Thank
we have
you.
one more question. One more question.
One more question.
I-
I'm a visiting scholar at NYU from Japan. My question about the extraterritorial application. A Japanese company would like to keep the DEI policy right now. If we abolish the DEI policy, it will affect the employing the American employee because therefore I think I wondering if Japan abolished DI policy, it may affect the American. It obstructs the. It is contrary to the America First policy because Japanese company it cannot vigorously employ more American people. So I think so. I mean, the extraterritorial application should be denied from the scratch because otherwise, I think basically anti-DEI should be only within the event in the United States. I think. However, why the current administration expand such kind of things to the foreign countries? Eventually, that may affect the America First policy. So I'd like to ask if the anti-DEI is contrary to the American First policy, then in such case, extra territorial application should be denied. I think. What do you think about it? Such kind of idea.
I think you're right that they're shooting themselves in the foot with respect to that and how it might conflict with America First in terms of outside the United States. But it's just another example of this administration using the power of contracts with various entities, whether they're law firms or other providers in foreign jurisdictions, even though they may not have any legal right for extraterritorial application to get them to go along with, the dogma here that DEI is a bad thing.
All right,
Thank
thank
you.
you. Thank you very much.
Great job.